Howdy. Today we'll be talking about the Supreme Court case Seller versus School Board of Manassas. This case highlights some details within the Individuals with Disabilities Education Act of 1975, or IDEA, as well as the Rehabilitation Act of 1973 and the American with Disabilities Act of 1990. In this court case, Christopher Sellers was 18 at the time his parents, Alan and Sherry Sellers, filed the case against the local school board of Manassas, Virginia. They argued that their son Christopher was not properly identified as disabled, nor was he treated for this disability. They were sued for compensation and punitive damages related to Christopher not receiving his free and appropriate education that was promised by IDEA, as well as the Rehabilitation Act and the American Disabilities Act. Before we get into the case, let's review these acts in order to better understand the case and the decision. The Rehabilitation Act of 1973, or commonly referred to as RA, made discrimination against individuals with disabilities unlawful. All public schools that receive federal funds, therefore, would have to comply with the act. The act is commonly known as Section 504. And eligible individuals are entitled to academic adjustments and services so that courses, exams, and services will be accessible to them. So since schools receive funds from the federal government, they therefore have to comply to Section 504, and they have to adjust any courses, exams, and services to be accessible to those with disabilities that are identified. Individuals with Disabilities Education Act, or IDEA, was passed in 1975, established grant programs to assist in state education. And all schools receiving federal grants must provide free and appropriate public education, or FAPE, for eligible children with disabilities. This is an important part in understanding the Sellers case because free and appropriate public education is discussed and whether or not it was maliciously denied on purpose to Christopher. The American with Disabilities Act of 1990, or the ADA, extends concepts of Section 504, established principles that are applicable to all individuals with learning disabilities in public education. In order to be covered by RA and ADA, a person must be qualified as disabled, otherwise qualified, denied job, education, or other benefit due to disability. So this is kind of a big point here, is that a person must be identified as disabled. As we will see in Christopher's case, he was not identified until he was 18. All right, let's get into the case. So Christopher Sellers and his family sued the School Board of Manassas for compensation under Section 504 of the Rehabilitation Act. His family argued that since he was not identified, he was discriminated against according to IDEA, RA, ADA, and deserved compensatory damages. He claimed this at 18. His family filed the claim at 18. He wasn't identified with a disability until he was 18. They also said that his test scores were low going all the way back to the 4th grade, and it was the school's fault that he was not identified, so therefore he was discriminated because he was not offered services as promised. He did not receive the free and appropriate public education that was promised to him according to the IDEA. So, what did the court say? Well, that the Rehabilitation Act does not require identification of disabilities, therefore the school is not accountable for recognition. This let the schools off the hook for having to require them to identify disabilities independently on their own. Section 504 only ensures free and public education. The IDEA does not provide compensation for punitive damages. It is not a type of law that you can go and sue and claim damages and get paid for. Since the Sellers could not prove Christopher was discriminated against when he was in school, then there was no violation. So since Christopher was not identified with a disability, there was no way that the school could have purposely been in violation of not providing him his services. According to the official court opinion, they had stated, at this late date, it would be difficult to determine what particular school officials and special education instructors should have done to evaluate Christopher or to provide him with particular services. So they didn't respond in a timely manner, and just because the school didn't identify Christopher as having a disability, it was not their fault. It did not seem like they didn't identify it on purpose for any particular reasons. So this come up with this other quote. In similar cases involving allegations of school districts' failure to timely assess and diagnose a child's disability, courts have been reluctant to find in misdiagnosis the evidence of bad faith or gross misjudgment sufficient to support a discrimination under Section 504. So from my understanding of this case, and what this is saying is that since other courts had found bad faith or gross misjudgment, that since they hadn't found this in this case, they could not make a discrimination claim under Section 504. So, what were the implications for this? Well, the implications was the court case helped to define Section 504 and that schools are not on the hook to identify disabilities. From my understanding of it, at least, I'd like to learn more about how schools do identify disabilities, and I'll talk about that in a second. It also reinforced that IDEA does not provide compensation or punitive damages, but only seeks to ensure free FAPE is occurring once the disability is identified. Also points to differences in IDEA and RA, and that the IDEA ensures FAPE. And that the Rehabilitation Act prohibits discrimination, and that in order to prove this, there must be more than a violation of FAPE, and that either bad faith or gross misjudgment, like we just talked about, need to be shown in order to violate Section 504. So, while Christopher might have had a free and appropriate education, it did not apply in this case because there was no misjudgment. So, what is my personal opinion on the findings? Well, my personal feelings is I kind of agree with the court from what I understand of the case. The school should have been better at letting the parents know about the test scores, but was that enough to cause negligence on their part as a school? Since Christopher was not diagnosed, it was impossible for his teachers to comply with any IEPs or address any issues he may have been having. It did not seem, from what I read, that the school purposely did not identify him. If this would have left the school at fault in identifying Christopher's disabilities, then I think it would have made teachers' jobs even more difficult, and that if they would be worried about being legally liable for diagnosing or misdiagnosing, for that matter, disabilities. Still not really sure how disabilities are diagnosed in schools, if that's part of the school's responsibility or the parent's responsibility, but I hope to learn that more in this class. But I think a good teacher would have made those connections between the test grades and maybe his performance in class that could have led to him being diagnosed. That concludes the video. Thank you very much for listening.